Wagner, that allocution, that statement, further demonstrates the role the court does not serve.
I know.
Everything you just said is perfectly appropriate. It's been heard many times before, as has the victim. But to the extent that there's a religious overtone, I don't factor in religious values. It's the same standard. The legal prescriptions, the laws of the government that I impose. I heard remorse. I heard your understanding and your explanation for it. But to the extent that you might, or somebody might have taken that as preaching, that's fine, except it has no meaning to me, except for remorse. If it was more than that, Mr. McVeigh helped me understand, but it just demonstrates that the same ill will and rancor that came from the victims, understandably, is now your faith experience on your side, neither of which is the role of the judge, the duty of the law. So it highlights what goes on in courtrooms on a regular basis.
Your Honor, what I might add to that, perhaps by way of further explanation, is that I believe from my conversations and conversations with my colleagues with Mr. Wagner, that the statement that he made there was he wanted to speak to the victim's family, and rightfully so. But I don't believe it was in any way intended to sway the opinion of this court when it comes to sentencing.
We said the same thing different ways.
We did.
I can't accept that.
We did.
For benefit of the record, a lot of the victims in the gallery walked out along the way as they're allowed to. So they don't have to hear what he chooses to say. It's how it works.
Yes, Your Honor.
In fact, this day is more intense than many, but it's all too familiar on the criminal court documents.
Yes, Your Honor.
With regard to sentencing, Mr. Wagner, the court has the same analysis. Severity factors, well, obviously, clearly, there's more serious factors. There are no less serious factors. With regard to whether you're likely to be a repeat offender or not, I'm not going to have a crystal ball to project where you are after a long prison sentence, so I'll just find that the recidivism factors balance out. It's unpredictable, but I did the analysis and thought about it. With regard to the penalties to impose, count 1, aggravated murder, life in prison. Count 2, aggravated murder, life in prison. Count 3, aggravated murder, life in prison. Count 4, aggravated murder, life in prison. Count 5, aggravated murder, life in prison. Count 6, aggravated murder, life in prison. Count 7, aggravated murder, life in prison. Count 8, aggravated murder, life in prison. Count 9, conspiracy to commit aggravated murder, maximum 11 years out of Department of Rehabilitation and Correction. Counts 10, 11, 12, 13, aggravated burglary, maximum terms of 11 years in prison. Count 14, possession of a dangerous ordinance, 3 years in prison. Counts 15 and 17, tampering with evidence, 3 years in prison. Counts 16 is tampering with evidence, 3 years in prison. Count 18 merges, so there's no sentence on 18. Count 19 merges, so there's no sentence on 19. Count 20, unlawful interception, 18 months in prison. Count 21, obstructing justice, 12 months in prison. Count 22, engaging in a pattern of corrupt activity, the maximum of 11 years in prison. And then count 23, unlawful sexual conduct with a minor, a 4th-degree felony because of more than 4 years of age difference. In that case, 18 months in prison, the maximum sentence. With regard to firearm specifications, the court's duty-bound under the recent Beatty case to impose mandatory 6 years on the first firearm spec taken from count 1 and 6 years on the firearm specification found in count 2. You're entitled to 2,244 days of jail time credit up through including today. You're required to register as a violent offender. You also have sex offender registration requirements. The sex offender registration requirements apply upon any release from prison, which would be for a period of 25 years, registering at least every 6 months with the sheriff in the county where you reside. If you change your address, take into employment, then you have to change your registration anytime you change your variable. A violent offender database, as you heard earlier, is a 10-year registration which can be extended. And if you fail to comply with the sex offender registration or the violent offender registration, that can be a violation of any terms of release or a separate felony at the time. The Chief Justice appoints retired assigned judges to work on cases where there's conflicts or problems. And I take that very seriously. It's a privilege after retirement to be granted the opportunity to come back and continue to help my colleagues. That's why I get out of bed every day. There's a need, there's a problem, maybe a skill to apply to resolve the need and the problem. That's how I got here. We talked about this with your dad months ago. I got two problems when I walked into this case. I'm going to explain the two problems. The first problem was a recommendation on your case that was the same as it was on your brother's, life without parole, which is what he got, right? How did he get there? He went to trial. He had 10 weeks of trial, and he had thousands of dollars and dozens of witnesses, and emotional energy and staff energy, people energy, resources energy to get him to his conviction. Yet the recommendation here is the same, giving you no credit for all the cooperation that you gave. As Mr. McKinney said, you don't have corroboration of a cooperative witness, you may not have any case. So I have to resolve the first problem is, how is it that I'm supposed to treat you the same when in fact you didn't act the same? That's the first problem. The second problem is, how do I resolve the good deal that your mom got? 30 years is a really long time. That's a really good deal for the level of the conduct, especially since she could have stopped the whole thing dead in its tracks before it ever happened. And I don't let her off the hook because she didn't go to the scene. I put her equally responsible because the eyes of the law put her equally responsible. So my second problem is, how do I resolve what looks to me like some sort of gender violence? And here's how I resolve it. I give you the opportunity of parole after 20 years on your prison sentence. So you do 6 on the gun spec, you do 6 on the gun spec, you do life on all the other counts, everything concurrent, with the opportunity of parole at 20 years. So 32 years out, you get your chance because you cooperated, because you did something to acknowledge the responsibility for the crime. That's not a deal, but that's as close as I can come to solving the problem that's handed to me by these ancient plea agreements. If everybody wants the last judge's sentencing deal, they should have sentenced him under the last judge. Everybody knew Judge Deering was gone right after the last trial, but nobody rushed it in to get it, and when I show up, I solve the problems the way I'm supposed to. So you get your chance to talk to the parole board 32 years from now. And then they do their job, whatever it might be. So I'm not going to sign off on a deal where you get the same for cooperating as your brother does for going to trial. There's the explanation. Court costs, processing, booking, pay the state. Medical expenses have to pay as a legal obligation. There's no victim restitution because they have civil remedies available. So you can go ahead and be excused. We're going to register you under both those registries. And we're going to take a break. So we're going to go off the record. Thank you to the lawyers.